We're at the new motion to dismiss. All right, so this is the new motion to dismiss. We went through the email evidence. If you want to see that, go check out the email video. And this is the official new motion to dismiss. They have a hearing scheduled for August 21st, 2023. As we know, the previous motions to dismiss were deemed moot. Okay, so hey, we say, hey, we have this trial coming up on the 31st, and this is submitted by Koil. Now, this is going to be our guy, Larry Zerner. Koil and Mitchell Clout will move to the court for dismissal of the plaintiff, that one video complaint pursuant to this rule. The motion is made on the following grounds. So this is while they're trying to get it dismissed. DW claim for declaratory relief is actually a claim for copyright infringement. But as you know, Tove and DW does not have a registered copyright. The plaintiff cannot bring a claim for infringement. This just mostly mirrors the email evidence that we just saw. In the claim for declaratory relief, if the claim for declaratory relief is dismissed, then the additional claims must also be dismissed because they would no longer be any federal court jurisdiction to the claim, which is true. They wanted declaratory judgment, they wanted breach of contract, and they also wanted to sue for accounting. So if the original lawsuit gets tossed out, they like everything else needs to be tossed out, guys. This motion will be based on the notice of motion in motion, the memorandum of points and authorities filed herewith, the pleadings and papers filed herein, and on such arguments may be received by this court as hearings of this motion. This motion is not made following the conference of counsel pursuant to something rule 7-3 because plaintiff's counsel John B refused. Look, they snitching. Hey judge, he didn't want to participate in a conference call despite our numerous requests for counsel for him to do so. So this motion is in the infra, as in they didn't review it. All right, let's keep going to it because we got a couple documents to go through, and this is the legal version of how you transcribe that email into a full-on motion to dismiss. So, Tove filed what purports to be a claim for declaratory relief, but which upon inspection is actually a claim for copyright infringement, and asking the court to declare that the defendant, which is Koil, is infringing on plaintiff's copyright by using software code allegedly belonging to DW without a license. All right. Plaintiff, which is, Tove via DW, all that good stuff, has styled his claim as one for declaratory relief instead of simply suing for copyright infringement because plaintiff did not register the alleged infringed software code with the Copyright Office prior to filing the lawsuit. So they saying, hey, you basically are getting this lawsuit to go forward because you're disguising it as declaratory relief when we all can see bright as day it is a copyright claim. Now, this is not going on DW didn't do the work. It's kind of like a legal technicality that they're trying to use to get the lawsuit thrown out. And this is what you pay the lawyers for. As Tove cannot get around the requirement of a copyright registration required to bring a claim for infringement by simply characterizing the claim as one for declaratory relief, the complaint must be dismissed without leave to amend. So, hey, no copyright exists. I showed you that. Now, when it comes to this factual background, this is going to rehash most of the First Amendment complaint. So because this is going to rehash the First Amendment complaint, we're actually going to skip it. However, if you want to see it, go to some of the old YouTube videos where we talk about it and you can see it for yourself. And I'll go very slow because maybe you want to pause it and read it for yourself. So let's go through it. This is still the factual complaint, which just rehashes all the information we already know deemed to be true. When we get to new information, I am going to stop it so you guys can see. All right, so now on the next page, as you see, we're about to get to some new information. The court should dismiss the first cause of action for declaratory judgment because this is a disguised claim for copyright infringement. Let's see what they have to say about this. We know this kinda to be true for the most part, because I've been covering it. So, plaintiff's factual First Amendment complaint purports to be for declaratory relief, but simply a review of the allegations. The FAC showed that Tove is asking the court to declare that defendants Koil are infringing on the copyright by utilizing Tracy's contributions to the Nopixel server without a license. Which, hey, they are still using DW's work, self-admittedly by Koil, which he said. Even though y'all say, hey, no more paid prio. Well, whatever he's using is still there. This expressly stated in 28 of the FAC, in which plaintiff alleges that is seeking the court's determination to whether Tove possesses a claim to ownership of any and all copyrights derived from Mr. Tracy's creative contributions to the Nopixel server pursuant to the Copyright Act, and whether Tove is entitled to prevent Koil from utilizing such contributions of the permanent and irrevocable license that Tove did not grant. That's their words, okay? When it comes to this license thing, man, it's clear as mud. Is clear as mud, guys. This is made even more expressively clear in the email that they attach, which is Exhibit 1, which we already read, where Tove's, the letter begins Tove's claim for copyright infringement. This is a technicality, guys. This is what you paying your goddamn lawyers to do. Hey, I need this case going. Okay, we can get it going. Now, some people may say ethically this is not right, or whatever you want to say. I don't know these guys' agreements, so I have no dog in this fight. Under that letter states that Tove believes it presently possesses claim for ownership of any of Mr. Tracy's contributions to the development of the game as it exists on the Nopixel server. The letter continues, a significant portion of the code developed for most recent version of the game as it exists on Nopixel server derives from DW's creative contributions. Now, the section of the letter concludes in pertinent part, Tove believes it possesses significant copyright infringement claims and absolutely intends to bring such claims against Nopixel if Tracy's reasonable demands brought by way of initial January 9th letter is not met. Remember the pay or else, guys. Pay or else. Now we're about to get into the technicality of everything, right? And you can probably see where I said technicality, is it fair? Because I don't know if people want things to be fair or if people just want this goddamn lawsuit to go away. So there can be no doubt that Tove's claim for declaratory relief is actually a claim for copyright. You keep seeing the pattern. Hey, this is a claim for copyright. Plaintiff is aware of this, but is also aware that they cannot sue Nopixel for copyright because it has not met the statutory requirement for the plaintiff to register any such copyright before filing a lawsuit. So I say, hey, this is a technicality, but is it fair? I know my DW people in the chat, and I know we got Koil people in the chat. As this court itself stated, in this lawsuit, copyright registration of a copyright akin to an administration exhaustion requirement that the owner must satisfy before enforcing ownership rights. All right, so there is the legal thing saying you have to have a registered copyright. Okay, Tove did not plead any facts showing that it has registered any copyright. Therefore, the FAC must be dismissed. Now, look, if Koil wins over this, it's fucking game over for Tove. No, this is Koil's team trying to find a workaround to get the lawsuit dismissed, saying it's a copyright claim. And sometimes you have a gotcha moment like, oh, you said copyright. It's not, you can't file a copyright because you have no copyright. Plaintiff's attempt to get around the registration requirements set forth in the Fourth Estate case is fruitless because Tove has it backwards. In order to sue for declaratory relief regarding the copyright infringement, the plaintiff must be with fear of being sued, not the one with the affirmative claim. The plaintiff must have a real and reasonable apprehension that he will be subject to liability if he continues the allegedly infringing conduct. Now, look, this is Koil's lawyer being a good lawyer, guys. And this is my interpretation, okay? So we have plaintiff, which is Tove, has a no fear of liability. Plaintiff has not been threatened with a lawsuit for damages from defendant. The threat that the plaintiff complains of if, after receiving the letter discussing defendant's copyright infringement, defendant's counsel stated in the February 10th letter that would be recommended their clients that they bring a cause of action for declaratory relief. Basically, this is saying no one is going to sue DW. So in order to sue for copyright infringement, you must be in fear of you actually getting sued. And Koil has said in videos he could sue, but he's not. Tove contemplating bringing a claim for declaratory relief of non-infringement does not give Tove standing to bring a claim for declaratory relief that has been infringement. If that were the case, it would completely subvert the Supreme Court's holding in Fourth Estate, Supra, in which the court held that plaintiff must have complied with the registration formalities for bringing a lawsuit for infringement, which we know there's no copyright number associated to DW's work. I've been saying it from day one. Not that I'm against DW or anything like that. I just have to go by the facts. It's not there. Now this is where they about to get into some thick the shits with them. Hey, if plaintiff has not complied with the statutory formalities and is not under threat of liability, the FAC must be dismissed without leave to amend. Without leave to amend is no redos. You can't come back with the amended complaint. So they're saying no redos. Or of course, if the court agrees and dismisses the first cause of action, then the entire case should be dismissed. And that is a legal thing. You can't, that's the head of the snake. Not saying that someone's a snake, but if you chop off the head, how are you going to sue for an accountant and breach of contract if you can't even sue for the first one? The FAC must be dismissed without leave. This is them asking to, hey, get this case out of here because they do not have a registered copyright. That is the whole basis of their case. And we have 2 more pages left, but you can kind of see where this is going. Okay. They need to basically saying you need to dismiss this. And if they get a copyright number, then they could refile the lawsuit. But without proof of a registration occurred before the lawsuit was filed, this lawsuit must be dismissed. What do you guys think? All my Nopixel fans. Then they throw in this 7-3 thing, which says, hey, basically this is them telling on John for not coming to the conference. Okay. And, they rehashed the emails and basically it said, hey, maybe Tove thought this was a waste of time, but Zerner has to keep his records that he did reach out and say, I want a conference. And John was like, nah, this shit's good enough. And they say they end it with, hey, we tried the conference with him. Please tell his ass to abide by court rules. And they respectfully ask them to, defendants believe that plaintiff's counsel had participated in the meet and conference. There's at least a chance that this issue could have been resolved without the need for motion practice. Should this case continue on, it is important that the parties are able to discuss their differences as to avoid wasting both their time of the court and on motions that could be resolved with a phone call. Now look, I know I said a lot, but this goes back to right here, the very first page where they have their hearing set for August 21st. All right. So we probably won't get nothing. We'll probably get another response from Tove on this copyright claim thing. Probably within the next 2 weeks or so. So what do you guys think? I know we it was a long one. When I cover these lawsuits, I want to make sure I cover every aspect of it, guys. That way you don't say, well, he didn't cover this. Like, no. I've literally showed you every form available for this Nopixel lawsuit.